So one of the traditional events that a sitting treasurer hosts is a dinner for the former treasurers. And it was a real privilege for me to host my first treasurer's dinner as a relatively newly elected treasurer. And I was really captivated by the conversation that we had that evening with many of the former treasurers. And we heard lots of stories, lots of wisdom, some really remarkable historical facts about the Law Society that I'd never known. And I thought after that we really have to share this with people outside of that select group. So because there's a lot of really interesting issues that have been with the Law Society for a while, and so I asked two of our former treasurers, Sid Robins and Jim Spence, to join me this afternoon in my office here at Osgoode Hall with a video camera present, and we're going to try and, I hope, recreate some of the discussion we had on that very special evening. It's one that I'm going to remember forever. So I'd like to introduce Sid Robins. Sid was a bencher from 1961 to 1971, and he became the treasurer in 1971 and served for 3 terms until 1974. And Jim Spence served as a bencher from 1983 to 1990, and as the treasurer from 1990 to 1992. And one of the things I really found amazing about that evening was to listen to each of you talk about some of the issues that you faced when you were treasurers. And in the case of Sid, that was, I think, about 40 years ago or more, a little over 40 years ago. And the other was about 20 years ago. So this is sort of 40, 20 in the present. I think it's a nice balance of perspectives, I think. But what struck me was how similar some of the issues that I'm dealing with as the treasurer these days were to the issues that you were dealing with in the 1970s and in the 1990s. And I wonder, I'm sure the issues have changed slightly, but it is remarkable. For example, and I'll throw this one out as the first example, both of you were dealing with the articling issue, the shortages of articling positions and whether articling was the right thing for us to be doing, in this century. That's a good example, I think, of some of the issues that we share, the three of us, in common. During both of your terms, there were benchers recommending that articling be abolished or amended or ended or changed. And Sid, you're still prepared, I know, to make that recommendation because you actively participated in the debate that we had in Convocation last November. So I'd like to start there, if you don't mind, and with the issue of articling and how you, Sid, for example, dealt with the issue and just tell us what happened in 1940. Because you were the first treasurer, I think, when a recommendation actually came forward and said, we should get rid of articling as an institution. So I'd like to hear. Yeah. I'd like you to share a little bit of that story for us.
Yes, well, Treasurer, many of the problems, many of the issues really remain the same, as you've said, to what they were when I was active around here. But the profession itself has changed considerably. We were dealing at that time with maybe 8,000 lawyers in Ontario. Today we have something like over 40,000 lawyers.
44,000 in Canada.
44,000 lawyers. So that whatever problems we had, they're more acute now than they were then. What happened was we were, at the time, confronted with the fact that a lot of articling students, a lot of students couldn't get articling positions. Mm-hmm. And we had to do something about it because it was unfair to have people going to law school and then not being entitled to be called to the bar because there was no room for them in the various offices around the province, mainly in Toronto, because most of them wanted to stay in Toronto, where they could fulfill their articling requirement. Mm-hmm. So we saw this coming, and we established a committee under the very capable leadership of the late Bert McKinnon. And it was a very well-balanced committee with representation from the bar, the bench, the academic community, and the community generally. And after some 2 years of study, in 1972, October, excuse me, the committee came down with a report. I was a member of that committee and treasurer at the time, to abolish articling. Mm-hmm. As I've said on other occasions, and as you know, the profession was very much against that recommendation. The profession simply wouldn't hear of it because the profession loved the articling system. Yeah. And no matter what their articlings were, they all looked back with great favor at the time when they were under articles, and everyone seemed to have a romantic view of what had happened while they were working in a law office for the first time. So the recommendation itself was a non-starter. We couldn't get anywhere with it.
You know, it's funny. I remember when we started in on the same discussion, the same debate here in Convocation. When it was about 2 years ago. You came up to me and you said, "Good luck, Tom. I tried that 40 years ago, and I still have the scars to prove it." He said.
That's right. Well, what we did then was we enlisted the help of a number of people, most particularly of Chief Justice Gale, mm-hmm. who was a great supporter of the Law Society, mm-hmm. and he held a number of 2 or 3 anyway of receptions over at the University Club. Mm-hmm. And invited the managing partner of some of the very large firms. I'm sure your firm, Torrey's, must have been there, and others were there. And he encouraged them to hire more students. Some of them were saying, it isn't worth the effort, we'll wait and hire graduates rather than hiring students. So he encouraged them to take on more students, and by one way or another, by hook or by crook, we got the positions filled. Now today you have a much more difficult situation. The numbers are much higher. 1 in 10 students can't get...
It's actually a little higher now. It was about 12% when we started, and depending on when you measure it, it's about 15% now.
So, and we had the bar admission course then, which you don't have now. So that, in a nutshell, is what we did then.
So how had the issue progressed by the 20 years after that debate, which clearly ran into a brick wall at the time because the profession was so opposed to any kind of substantive reform to articling? How did you come up under your term?
I recognize in Sid's description of how things were then, attitudes that continued in my time and when I was treasurer from 90 to 92. There was also a concern about the inability of some graduates from law school to find articling positions. My recollection is that we didn't have reliable statistical information, and so it remained anecdotal, and I think it was left at the level of individual efforts. There were certainly proposals that articling should be eliminated, but those proposals never found, in my recollection, general favor. A lot of those proposals came from individuals associated with larger law firms who by this time were now employing large groups of articling students, no doubt in part because of the initiatives started in Sid's time, because articling had become very much a part of the practice of law in Ontario, throughout the province, including in the big firms. And they were saying, we don't need articling. We can find the good students as they come out of law school and train them ourselves. Elsewhere in the province, I think lawyers had found all sorts of good ways to put articling students to work, and they regarded it as important as well. I think there was the same attitude that Sid mentions, that people looked back on their own articles and regarded their articles as having been very important to their education as lawyers, and they couldn't see how they could have had an adequate education without them. So all those factors, I think, led to there not being any collective action on it. But what was happening was that we were engaged in restructuring the bar admission course, both in terms of the amount of time it took and its content. And the bar admission course had been abbreviated, and it had been focused specifically on skills training. There had been a great deal of education in substantive law, and it was decided
in the bar admission course?
In the bar admission course, and it had been decided that that was inappropriate and unnecessary, that we should be able to look to graduates from law school to come into bar admission training with having already studied those courses that they would need. So we shortened the collective period of articling plus bar admission, but the principal focus in that effort of abbreviation, I think, was on the bar admission program. And the effort with the bar admission program was, I think, modestly successful at best. It was clearly a work in progress, and it went through transformations after that. I wasn't here for some of those transformations, but I certainly heard about them, and it was apparent that benchers were continuing to think hard about what would make the most sense for bar admission training, and I guess incidentally, therefore, for articles.
Well, you know, I became a lawyer a couple of years before you became the treasurer. So I was very much used to the system that I went through the system just before the reforms in the 90s took place. And I'm one of those people who thought my articling experience was wonderful, and I loved the bar admission course and used the materials for many years after that. You know, I guess to that degree, I was certainly a traditionalist. But having gotten into the issue, since I became an elected bencher and head of the articling task force and then the treasurer, you know, the flaws in the system became quite apparent to me, and Sid, you right from the 70s saw those flaws, I think, and you were very strongly of the opinion in the 70s that there was a better way.
Yes.
And last November during convocation, you maintained that view. And I'd like to ask you, what motivated you to coming to that conclusion? What were the things about the articling system that you felt needed to be reformed?
Well, first of all, I was struck by the fact that the training in the articling system was so uneven. That's the word we always use when talking about the articling system.
To be kind, I suppose.
Yes. Some people had good articles. Yeah. I personally had very good articles. And my term as a student, an articling student, equipped me, I think, to some extent, to go out and practice law by myself at the beginning. But too many of my colleagues, too many of my friends really had very, very little training. There was a good card game going on here most every lunch period. There were all sorts of things being done, and or else they had a friend who didn't need a student but was prepared to sign their articles at the end of the term. There was a good deal of that that went on. So I thought the whole thing was a bit of a farce to some extent. I can't say entirely. And I think I was also affected by the fact that I had spent some time in the United States. And I got to know quite a number of students, good students, at the Harvard Law School. And I knew what they were doing and what they had done, and they had no articling system down there. And they went out and did their bar examinations. I had one particular friend who went back to the St. Louis area, and he had never been in a law office before. And they became damn good lawyers. And so I said, why can't we do the same thing here? Why are we so wedded to the articling system as it existed? So I thought that we could do better than what we had, but this is sacrosanct.
Well, you know, that's a very interesting point. Because when we were going around the province a couple of years ago, when we took our traveling roadshow to Windsor, for example, and the Windsor Bar has a great deal of familiarity with the Detroit Bar and how they do it over in Detroit. The proposition of getting rid of articling was just really not a big deal for them. They thought, yeah, sure, go ahead and do that. That's fine with us. But if you went to other parts of the province, Sudbury, for example, you know, they're very much wedded to the old way of doing things. You know, and I don't want to be pejorative about it because they have some pretty good reasons in Sudbury for wanting to maintain that. But that's very interesting. So it's in part your exposure to the American legal education system.
I think so. Yeah.
Interesting. Okay. Well, another issue that I think probably, and I'd like to get your take on how significant this issue was when you were both treasurers, but one of the issues that we've been dealing with in the last couple of years, as you probably know, is retaining women in private practice. And the statistics are that now in this day and age we have more women going into law school and more women graduating and more women going into private practice but leaving private practice within about 5 to 10 years. And we've been struggling with, you know, how do we affect change in a real way to make it more attractive for women to stay in private practice. How was the issue of women in the profession framed when you were the treasurer?
Well, we didn't have any problems about keeping women in the profession. If we had problems, they were problems in trying to assist women to coming into the profession, in getting articling positions, and in becoming lawyers. The change in the ratio between men and women in the law schools hadn't changed. In the early 70s, it hadn't changed to the 50-50 or thereabouts that it is today. So we were concerned about I was concerned particularly about what I perceived to be some of the discriminatory practices, whereby the young ladies who wanted to come to law school couldn't get decent positions in the firms, not just in the major firms, but in some of the larger firms, or some of the smaller firms also. And we heard all sorts of comments about really stupid things that lawyers said to women when they were interviewing them. I mean,
and actually, we still hear stupid things being said to women in interviews in 2013. I think it's not a problem that's completely gone away.
Well, if I can take another minute, Treasurer. I was invited to attend a conference at the University of Windsor called Women in the Law. It was the first time that conference had ever taken place. It was supposed to take place annually. Whether it's still taking place or not, I don't know. But every prominent and not so prominent woman lawyer and a lot of students throughout the country were there. And it was really an experience, I'll tell you. I knew that there was going to be a lot of criticism of the Law Society and the profession generally. So I decided,
because of the attitude towards women.
Because of the attitude towards women, and because of the type of comments we're talking about, and because of the general complaint that women had in not being advanced in the profession, in not becoming partners in firms, in not being given an equal opportunity as compared to men in advancing in the firms. So, as you know or will not be surprised to know, I was always very concerned about discriminatory practices in the profession. So I was invited to this big conference in Windsor. And I decided, and I spoke to some of my leading colleagues around here, that it's time that we had an anti-discrimination rule of professional conduct. And they agreed with me. So I went to convocation. We had no prior discussion.
So this was something that came out of that Windsor conference? Or is it just...
I'm now talking about a few weeks to a month before the Windsor conference.
Okay.
And I thought that at that time we should pass a rule of professional conduct which forbids lawyers from engaging in discriminatory conduct. And we passed a resolution to that effect. It went through. Convocation was wonderful. It went through without any dissenting voices. And I asked convocation to remain silent about this resolution because I wanted to announce it at the conference in Windsor.
Okay.
I thought this would be a great opportunity to tell them what we're doing.
Yeah, how'd that go?
Well, that's a story. That's a story in itself. But
did the news stay pretty much close to the chest before you got to Windsor?
Not a word was mentioned. But if I can, I can tell you it's kind of an amusing story.
Yeah.
I was on a panel, and the panel consisted of a young lady who was either a student or had just graduated, who seemed to think that she could make her point more aggressively and more substantively if she used foul language, which didn't exactly cause me to have any great respect for her. Mm-hmm. There was another woman from the West who was very nice. And then there was a woman on the panel by the name of Sullivan. She wasn't a lawyer. She was a legal secretary. And she had achieved a great deal of publicity in the Windsor paper. She's from Windsor, and elsewhere in the province. She was busy organizing all the legal secretaries into a union. Mm. And the idea was that they weren't being treated fairly. They were required to do all sorts of menial tasks, go out and get coffee for their bosses or a package of cigarettes or whatever the heck it was, and they were complaining about it. So, and the chair of that meeting was someone I'd never heard of by the name of Dubé. What's her name in the Supreme Court of Canada?
LaRue Dubé.
LaRue Dubé. Mm-hmm. She was the chair. I'd never met her. I'd never met her before, and she's a vivacious person now.
She was here for lunch a couple of weeks ago. And
Claire,
Claire LaRue Dubé.
Claire LaRue Dubé. Gloria knows her too, and she was the chair of this panel. Yeah. So she called on Miss Sullivan, and Miss Sullivan gave a stem winder of a speech. It was really something, and the audience cheered. There's a full room in that amphitheater classroom or moot court room at Windsor. And then I got up and I had a prepared text. I had, I think, a wonderful speech. And I had this announcement about this discrimination, anti-discrimination bylaw, resolution, rule of conduct of the Law Society. So I announced that. And I said, told them all about it. Told them that this was the first public announcement of it. The response to my speech was polite but tepid.
I'm glad I'm not alone.
When the meeting concluded and Claire LaRue Dubé summed up what the speakers had said, she came to Miss Sullivan. And she lauded her to the sky, and she said, Miss Sullivan, she said, you'd make a great lawyer. Then she turns to me and she said, and Mr. Robins, you'd make a great legal secretary.
I'm not surprised that she would have said something like that. Somehow.
I didn't know her at the time, but the next day, practically, she goes to the Quebec Court of Appeal, and the day after that, she was in the Supreme Court of Canada. That was fun.
Amazing.
So that was the story behind that particular resolution of convocation. But the women had some very legitimate complaints. Yeah. I mean, some of the lawyers, these young ladies were standing up and complaining about the fact that when they went in and interviewed people, the lawyer asked them how they reacted to having their monthly period and whether they're able to work after that. And they start putting these questions to me. I said, I'm not here to defend every stupid ass that's a member of the legal profession. I'm here to talk about what the Law Society's doing. Mm-hmm. But those were the type of complaints they had.
Wow. Yeah. Well, I guess maybe on that score we've come a long way.
Yeah, I think we have.
Jim, what was your experience?
Well, by the 1980s, when I became a bencher, I don't know that we'd come that far. I remember when I was campaigning for election the first time, I attended what, as I understood it, was the first time that the Law Society had held an education session on the matter of women in the legal profession. Until then, and generally the topics usually were on substantive areas of the law. And so I attended that. It was attended almost entirely by women. There was one other male there, and he was a speaker. And I was impressed by what I heard. I didn't forget it, but I noticed in convocation that while these concerns were there and were being spoken about, nothing formal was happening in a significant way. But then we held our first benchers retreat in about, I think, 1988, and our topics included the existing and coming changes in Ontario in terms of demographics, workforce, and the profile of the profession. And it was apparent that the place and role of women in Ontario, in the workplace and in the profession, was going to be an important issue ahead of us. Then in our Research and Planning Committee, we established for the first time a subcommittee on women in the legal profession. And then in 1990, Convocation altered that into a standing committee of convocation. And their committee went to work on preparing a report on the circumstances of women in the legal profession. And they published that, they presented that report to Convocation. And their conclusion was, for the reasons that they set out, and it was a very detailed and lengthy report, that there was a clear pattern of systemic discrimination against women in the legal profession in Ontario. And that report was adopted by the benchers unanimously and with applause in the Convocation room at the time. Mm-hmm. And thereafter, the Committee on Women in the Legal Profession sought ways to implement their concerns and proposals that were initiated in their report. So in my recollection, that was a kind of a watershed moment, and many of the initiatives that have been pursued in the Law Society since then, I think probably can be traced back at least to their inspiration at that time, and of course in the earlier work that was being done that Sid's spoken about. Mm-hmm, mm-hmm.
I want to touch on a related issue about equity and diversity in the profession, and it's a bit of a delicate subject because I've heard so many stories about the various barriers to the profession that existed not so long ago, and arguably I suppose to some degree exist still. But I want to introduce this subject by reading a newspaper, part of a newspaper article that was published about Sid when he was re-elected for his third term. He said, the article read in part, "You only find out later that Sidney Robins, 52nd Treasurer of the Law Society of Upper Canada, has yet to blink first in any confrontation with his hard-nosed, scrappy colleagues. It goes on and says, since May 21st, 1971, when he became the first Jew ever elected of the treasurer of the 160-year-old one-time stronghold of transplanted British Protestantism, Sidney Robins has, and it lists a number of accomplishments that he achieved. It goes on, the article goes on and says, what is Sidney Robins up to and where is he headed? It is a reasonable question, if only for the fact that it is being asked testily by older, crustier colleagues inside the Victorian chambers of Osgoode Hall, where historically boat rockers have been as welcome as Bengal foot rot.
I never knew what Bengal foot rot was.
I didn't know what it is, but apparently somebody did in the 70s. Perhaps one of those old Protestants. But I'd like to open up what I think is probably not one of our best chapters in our history. Sid, could you comment on that?
Yes. Well, it certainly isn't one of the best chapters in the history of the society. I ran in 1961, and that's when I was first elected. Isidore LeVinter ran in 1956. Isidore was the first member of the Jewish faith to be elected a bencher. And I'm sure that it was very difficult for him to get in. He got in, and he acquitted himself very well here. He was a wonderful, wonderful bencher. I was elected, I think, primarily as a result of the fact that I knew a lot of people in the profession through my activities at the law school. Mm-hmm. So I represented a new wave in the profession, so to speak. Mm-hmm. I was the youngest bencher, the youngest by far for quite a number.
I think you were, almost a record, certainly in this century.
That's right, and stayed that way for quite some time.
And you were a boat rocker, apparently.
Well, apparently I was, but I rocked it very, very gently, and very deliberately. Yeah. Because I didn't want to antagonize people. I think I have some capacity for getting along with people, regardless of what their background is. And when I was elected treasurer, I received dozens upon dozens of letters from Jewish lawyers, many of whom I didn't know, who had graduated in the 20s and the 30s. And the general tenor of those letters was that I never thought I'd live to see the day when a Jewish lawyer would become treasurer of the Law Society. The Law Society was the bastion of the WASP aristocracy, so to speak, in the legal profession. It wasn't just the Jewish lawyers. There was no Roman Catholic treasurer of the Law Society until Brendan O'Brien was elected, if I'm correct. You're shaking your head. That is correct, I think. And Brendan was elected just 5 years ahead of me.
Of course, there have been no women
elected. There were no women elected till I think Laura Lake got elected. So I considered that a privilege and a responsibility, and I took and still take great satisfaction out of the fact that my election assisted in bringing a lot of people closer to the society, because up until then, the only connection, the only thought they had about the society is that this is a police-like organization. All they're interested in is finding if we made some error, or if we did something wrong, and then disciplining us. So what I tried to do, and what my colleagues tried to do, is improve relationships with the profession, primarily through continuing education programs. We initiated a lot of the continuation programs that developed and went on, and making the society appear, and I think, in fact, more accommodating to minority groups, because it wasn't just the Jewish lawyers, it was other groups, many of whom were coming into the profession, and I knew a lot of them personally through my activities at the law school. So that was one of the things that I take great pride in the fact that I was able to be here at the right time. And
of course, the 70s was such a time of tumultuous change.
That's right.
Not just here, but
yes, and
through society
I
generally.
received wonderful cooperation from all my colleagues, and all those so-called old-time WASPs who were around here couldn't have been nicer to me, and couldn't have been more accommodating. And
So when you came here first as elected as a bencher and then as the treasurer, are you saying you didn't actually sense that kind of resistance to having a non-Protestant in their midst?
I never felt any discrimination here at all. I never felt any antagonism. I never felt any anti-Semitism. I never felt any of those things when I came here. Now, if you take a look at Christopher Moore's History of the Law Society, he says in there that when I was nominated for the treasurership, that one Stan Fennell, who was a lawyer up in Cornwall, and quite a distinguished member of the bar, by my standards at that time, I can't say it today, an older man, and he says, he's quoted in the book as saying that he was approached by a number of lawyers, in effect to stand against me so that someone of my faith wouldn't be elected treasurer. Really? I had, until I opened up that book, it's been out since I think about 1995, something like that, I never ever heard any such thing. Stan, I would have beaten Stan if there were an election. He didn't run. He didn't run. We weren't close. I knew him, and we were always courteous. And he, in the book, disassociates himself from that effort. Yes. But he said that he was approached by some who did. I've never really believed it, but in any event, that's what happened.
So Jim, under your watch, I believe the Law Society actually formally established an equity and sort of diversity committee to start with.
Yes, one of the first things we did in the first convocation that I chaired was to establish, along with the Committee on Women in the Legal Profession, the Committee on Visible Minorities and Members of First Nations in the Law Society, in the profession. And that initiative was also considered to be a very serious and important one by benchers. I think the climate in the profession as at large had changed in the intervening 20 years from the climate that has been mentioned and Sydney's spoken about. I think things had loosened up considerably. It's perhaps not for me to say, but I didn't notice any problem amongst benchers with the kinds of things that you've been mentioning in your questions to Sid. And in the contrary, I thought there was pretty immediate support for the initiative of a special committee. Once again, the task was then for the special committee to undertake the effort to figure out what sorts of things the Law Society should do and could do. And in the initial stages, that's always difficult because everything's at large and open and unresolved, and there didn't seem to be that much to go on. One of the opportunities that came our way within the next year, when there was a royal visit by the Prince of Wales to Toronto, was to present special awards. They were really in the nature of bursaries to support the bar admission legal education of members of visible minorities and First Nations groups, and a special ceremony was held in Osgoode Hall for the presentation by the Prince of Wales of those awards to the recipients from those groups. It might seem like a gesture from the past to mention a royal visit, but those things happened then, and indeed when Sid was a bencher, as I recall from reading, there were 2 royal visits in your time, the Princess Royal, and then when you were treasurer, Her Majesty was here for the opening of the courts and at Osgoode Hall. And every Prince of Wales had been an honorary bencher of the Law Society, so it seemed to us that.
Do you think do you think he reads his material?
In the address he gave to convocation, he did say that members of the royal family are honorary members of so many legal institutions around the world that if they didn't have other work to do, they could set up their own law firm. That hasn't happened. I was mainly faulted by my colleagues for not having found Princess Diana to come rather than the Prince of Wales, but that wasn't necessarily a majority view. In any event, the important thing was that those awards were given, and they were given in quite a fine ceremony, and so far as we could tell, they had a very good effect, because so much of these things for members of those communities was morale and legitimation, and this seemed to be a strong and clear way to assist in that effort in the early stages.
In fairness to the society, what was happening here was really reflective of the temper of the times.
Right.
It wasn't just here. It was in all the major law firms in Toronto and elsewhere in the province, maybe throughout Canada. And there was discrimination right down the line. And happily, I don't feel it today from what I know in talking to you younger lawyers. And there's a much better mix than there ever was before.
Yeah.
Yeah.
Well, you know, I one of the things I remarked upon when I first took over as the treasurer is, you know, you do the call to the bar ceremony.
Yeah.
And now we're calling about 2,000 people a year, and the diversity you see.
Yeah.
The challenge for many benchers now is to get their tongues wrapped around the names of the people that are being called, who have come from all over the world. Yeah. So that's the one experience at that end, where the new folks are coming into the bar. And then, of course, the other thing you probably remember doing every year is you go to these opening the court services, and the role of the treasurer quite often was to read the names of people who had passed on, and the people that are passed on are they're all British Protestant names, sort of white Anglo-Saxon names. So it is very interesting to see that. In the space of a generation, essentially, the face of the profession has changed
very much
dramatically.
So. Certainly, all of us who are judges recognize daily that we live in a multicultural society and that we have a strongly diverse bar in Ontario.
Now that, of course, presents its own challenges, doesn't it? I mean, you're now a judge, of course, Jim, in the Superior Court. And we have all sorts of people practicing now. We don't have the same kind of hegemony that was once prevalent in the profession. And this sort of is a good segue into another subject that I wanted to raise with you. Both of you, I think, in different ways, were dealing with other sectors, if you could call it that, or other individuals who wanted to provide legal services either within their own community or, as part of, whatever kind of activities they were involved in. And the whole issue of paralegals, has been an ongoing issue that the Law Society has been controversial for the Law Society over the years. And of course, we began regulating paralegals in 2006. Can you tell me what the state of play was when you were both when you were treasurer?
Well, I'm going to pass this one to Jim, because when I was treasurer, there was very little interaction or supervision of paralegals. We didn't concern ourselves with paralegals. The truth be told, we looked down on paralegals. Our concern was in the Unauthorized Practice Committee in making sure that paralegals weren't doing the work of lawyers. And if they were, we were all too anxious to prosecute them. But I don't recall any mutual interests of ourselves and the paralegals. We kept an arm's length from them. We had nothing to do with them.
I think basically the terrain hadn't changed in the time that I was here, except that there was a gathering awareness that there were a number of activities that it might make good sense for paralegals to be able to carry on. But we were still then a long distance away from the question of licensing, and many people thought that if there was to be a licensing program, then in fact it would be sufficiently onerous that it would have quite a different effect on the practice, that it would no longer be a kind of unregulated field in which lots of people could just help themselves, but it might discourage people. And what would come of that? How much social good would really be achieved through those things? Well, of course, all of the discussion about these things was necessarily hypothetical. No one knew what would be the results if there were to be a licensing program. And so that was an idea that had to work its way towards being enacted, and it required there to be a developing sense that there was a range of activities in which there could be effective and efficient licensing. And I guess over time, and with government strong interest in the matter, that came to be the view as to what should be done.
And with some judgments of the Court of Appeal, I might add, that were very critical of the lack of education, lack of supervision of paralegals acting in their own sphere.
Well, there's that famous line from the Court of Appeal decision which says, you need a license to sell T-shirts on the corner of the street here, but you don't need a license to provide legal services, unregulated legal services.
Yes.
So, and of course that, there was, that led to, there's a famous prosecution of Brian Laurie and his paralegal operation, and of course he became one of the first elected benchers from the paralegal profession. But again, this is sort of so now the reality that we live with now here at the Law Society and in Convocation is that it's been opened up, so that we have non-lawyers like paralegals involved in the governance of the Law Society, and indeed we're now governing and regulating two professions. But I know that both of you were quite concerned about the closed shop type of reputation that the Law Society had, and I know that both of you made efforts to open up the Law Society to the public, to make it more transparent. And Sid, I think under your tenure, the Law Society saw its first lay appointee as a bencher.
That's right.
Could you tell me about your efforts to do that, and why you thought that was so important at the time that you were doing it?
I wasn't the first one to recognize, of course, that there should be more transparency in the Law Society in our relationship with the public. Prior to my becoming treasurer, Bill Howland, I believe it was, during his term, we established something called the Law Society Council. The Law Society Council consisted of, I think, the presidents of the county and district law associations, and some lay personnel, I think maybe 10 or 12 laymen, and some benchers. And it met annually, perhaps semi-annually, my memory is annually. And we met up here in Convocation Hall, and we twiddled our thumbs trying to decide what we were supposed to do. Really, there was very little to be done. We got a report from the Law Society telling what had been going on. It received no coverage. We appointed a distinguished member of the public as the chair, excuse me, of that council, John Bassett, who was at the time publisher of the Toronto Telegram, just before the Telegram went under, and he began to conclude that this is a wasted effort, that there's nothing happening. And by this time I had become treasurer, and I said, we've got to do something about this, because we're just wasting time, and we're going to be getting a lot of criticism for this, because it doesn't achieve the purpose that was intended. So, and the Globe was very instrumental on this. They wrote a series of editorials. One of them I remember was called Behind Closed Doors. And they were highly critical of the Law Society and the way in which we were excluding the public. So I took the position that having lay representation in convocation was an idea whose time had come. And we passed a resolution allowing for 2 lay people on convocation. The Globe thought that that was an idle gesture because they didn't have a vote. And they couldn't have a vote because we did it voluntarily, and there was no legislation that would allow them to have a vote. We had 2
You didn't like the way they were voting, you could just get rid of them.
Well, there are a lot of people who objected strongly to having lay personnel in convocation. They thought that it would lead to some infringement on the principle of the independence of the profession. That should have lay people telling lawyers what they should or shouldn't do in the administration of the society and the administration of the profession. So we went back to the drawing boards, and as I recall it, we increased the number to 4, and we got 6.
The government really thought it was a great idea.
The government thought, the government they were looking at the public on this, and they nominated 6 people. By this time, I think it was just about the conclusion, or maybe I had already ceased to be treasurer. Stuart Tom was treasurer at the time. But we got 6 very good people came in here, and the lay benchers have been very substantial, contributing benchers ever since. So that's my recollection of what happened at the time.
And Jim, what about you? I know that some changes in the way convocation did its business occurred when you were...
Yes, I might mention with respect to lay benchers that the practice of their appointment and their participation in convocation and in the affairs of the Law Society was well established by the time I became a bencher and then treasurer. And lay benchers were particularly important in dealing with complaints about lawyers and also in discipline hearings, and they participated fully in convocation. And they were well accepted. Indeed, looking back, I recall that we never saw an instance, which is frequently a concern mentioned, of lay people in an organization such as this pursuing some private agenda of their own with a particular hobby horse. We never saw that. The lay benchers were always concerned with the public interest generally, and their focus was always very acutely on that. In terms of openness of convocation and transparency, there were 2 major developments. One, just before I was elected, there were allegations that the Law Society had dealt with favoritism and bias towards one of its own members in connection with a vexing and controversial discipline case. And it was so controversial and so much in the public press that convocation under the leadership of my predecessor, Lee Ferrier, decided that we needed a public inquiry into how the Law Society had dealt with the matter. Now, when I say a public inquiry, the inquiry was in fact not conducted in public, but it was conducted by a third person independent of the Law Society, the retired Chief Justice of the Trial Court of Manitoba. And he reported in, thankfully, that he could not find evidence of bias or favoritism on the part of the benchers. We were at risk of being vulnerable about our independence as a self-governing body if we did not deal with this matter fully and in a straightforward way. And when I was elected treasurer, that had been determined, that report had come in and been accepted, and it was very important to me to watch to see what the public signs were in the media about how that report was being accepted and whether or not the issue still had any fire left in it or not. And it became apparent over the next couple of months that the matter had simply died down. It had been put to rest through that public inquiry. The other thing that was ongoing at the time that bears on this topic is the development of public meetings of convocation. And my recollection is that that went in stages. At first we opened the convocation room to the public, which in practical terms meant those members of the media who were interested, and they would sit at the back of the convocation room. There was never that much room there. Then I think we had closed circuit TV to enhance that or to add to that. And
so that came in under your watch.
I think that came in because eventually, if we knew we had a topic that would attract more than a large handful of people, we would have to hold the open convocation in the large convocation hall. And we did that for a number of issues. So by the time my term as treasurer was over, I think the practice of the public holding of convocation was well established.
Yeah. And of course, last October and November was the first time we saw a convocation actually being webcast to people so they could watch it over their computers. So I guess that's what's happened in the 20 years since you were here. I want to talk about I want to talk about another subject that I think is always with us, and that is sort of the broader subject of access to justice, but more specifically about the Legal Aid Ontario, and through both of your terms, I think this was quite an issue. We know that the Law Society's referral service was launched in 1970, and the Law Society originally sponsored the legal aid plan and administered it, I think, beginning in about 1967, I believe.
67, 68, yes.
And it was during your term as bencher that all got started. Jim, as treasurer, you were concerned with the amount of time that was being spent by benchers on administering the plan. So that the plan gets started, and then all of a sudden becomes all-consuming almost during your term, and then it leaves our jurisdiction and migrates over to the government to be administered there. Can you talk about legal aid and how important that was as an issue when you were the treasurer, Sid, and then see, and I'd love to get Jim's take on how it evolved from there.
It was at the beginning of my term a sleeper issue, in the sense that when I started, I thought that legal education was going to be my prime concern, and there were a lot of negotiations with the various law schools, the subject matter of the courses, all the sort of things that go into legal education. Mm-hmm. I found that legal aid became the number one problem, and there were all sorts of people who were critical in one way or another of what we were or weren't doing in legal aid, and were critical of the Law Society administering the legal aid program. They thought that legal aid should be run by some government organization or some crown corporation. And eventually, the government established a commission to look into the question of legal aid. The commission was chaired, very good chair, by the Honorable John Osler, who was on the trial court at that time, and his counsel was Ian Scott. I made a presentation before it. If you're interested, you can find my presentation reported somewhere in the Law Society Gazette. We very much opposed the establishment of a crown corporation. We were anxious to retain legal aid and the independence of legal aid and the lawyer-client relationship that existed under the legal aid plan, rather than having public defenders and other government employees running the show. Mm-hmm. We did, to minimize some of the criticism, and because we thought it was right, start some community law centers. We had the Parkdale Center. We had a center, I think 1 or 2 up in Ottawa. We had other centers. And I remember, it was very aggravating to me at the time, a university professor who did some statistical study from which he concluded that lawyers, that the legal advice that was being given by lawyers under legal aid was deficient or wasn't really in keeping with the high standards of the profession or something of that sort. It was very critical. And he had statistics of some sort. Well, I read this stuff and I said, how the devil can you have statistics on this? So the Globe called me and I had a little fun with them. I said, statistics. I said, I've looked at those statistics and it's just like saying that Marilyn Monroe has an overall statistic of 30 inches. I said, that doesn't give you the full picture. so we had a little fun with them, and it was a silly report, but it caused us some anguish at the time. And I had some law professors who were, you'll see it in that article, who were talking about more effective ways of delivering legal services. And we did our best to maintain the solicitor-client relationship. We thought it important at that stage to give the client the ability to choose his or her own lawyer. I know that's been changed. I know that the job just became, like legal education, too big for the Law Society. It may have been when you were around, Jim, but that's about where I left it.
So pick it up where you take over, Jim.
Well, I think your comments telegraphed the situation that was developing when I was in the Law Society. There was a well-established legal aid program, and I might mention as well, you mentioned it also, the community legal clinics were an important program initiated by then Attorney General Roy McMurtry and were administered wholly or in part by the Law Society. We always had a report to Convocation with respect to the work of the community legal clinics, and there were a great number of them throughout Ontario, and the work that they were doing was quite important in supplementing the work that was going on in legal aid. In legal aid, the problems were that there was such a demand for assistance through legal aid that the cost was mounting. And it became a big problem in Convocation to figure out how we would contribute to this. Legal aid and the committee that oversaw legal aid was made up of a combination of benchers and other persons from the legal aid and justice community. And so it had a degree of independence from Convocation, but it reported into Convocation where decisions were made about programs. And the government provided funding, but the legal profession provided funding. And as the system grew more expensive, the contribution made by the profession through the Law Society dues increased. And that became a subject of considerable controversy. There continued to be many in the profession who considered that legal aid was in the nature of a social service, and it was not part of the responsibility of the profession to provide it and do a large part of the funding for it. And many benchers held that view, and many highly respected members of the profession did. But of course, there were two views in the matter. I was of the other view. It seemed to me it was part of the responsibility of the profession, as a profession, to ensure that these matters were dealt with properly. But I was very aware of the funding problem, and it was also causing a difficulty in respect of the scope and qualification for the services, because if there wasn't enough money for all of the service that seemed to be warranted, then the question was, where do you draw the lines? And so notions of triage were starting to develop. And I think eventually, and then it was after my time, what happened was that the problem of the size and funding and the triage factor became so difficult that the Law Society, and at that point I thought, I can see now why there needs to be the change. The Law Society agreed, as I understand it, with the proposal that was made that the government would come in with the government legal aid plan. With all the reservations about doing that, still that looked like it was going to be the best way for the future to provide for a well-based and a widely servicing legal aid program.
Yeah.
I'm going to shift gears a little bit. I want to talk about an issue that I believe came up under both of your watches, and then move it slightly into a more philosophical question about the Law Society. We recently have dealt with in one of our annual general meetings a motion to change the name of the Law Society of Upper Canada, and change it to the Law Society of Ontario, or even the Ontario Regulator of Legal Services, or something like that. I think the treasurer, the position of treasurer, is called the treasurer here in Ontario, but in every other common law jurisdiction, it's now been changed to president. So I think you both dealt with that issue. I believe people who are thinking, we've got to change the name of the Law Society.
It really didn't come up while I was treasurer. What happened was it was considered by me to a very limited extent. We had, for some program or other, retained some public relations people to make some sort of a study for us. And I asked them to take a look at the title treasurer. I was concerned about that. I was never in favor of and never suggested changing the name of the Law Society of Upper Canada to anything resembling Ontario or the Law Society of Ontario. I always thought that this was the name under which we were originally incorporated, been in existence at that time for 175 years. I wasn't going to propose changing it, and I would have opposed any suggestion that we do change it. But I found the title treasurer to be very confusing. And I think that in England they still call them the treasurer. But I thought that it wasn't productive when we went out on the hustings, so to speak, or went to various other professions. We went to various places to represent the Law Society, to be introduced as the treasurer, because everybody thought we were the people who looked after the money. And we had nothing to do with the money. So I had these people take a look at it, and they gave me a short report indicating that it was confusing. They agreed that it was confusing, and thought that there's much to be said for changing the name. So then, just as I said earlier, when I decided to rock boats, I only rocked them when I thought that there was some success possible and that I wouldn't overturn the boat. So I started to ask some of my colleagues at that time about changing the name. Well, I got a lot of opposition to it. They were not in favor of doing it. And I said, if that's the case, then I'm simply not going to pursue the matter. And I let it go there. I had more trouble with the name Osgoode Hall Law School with York University than I did with the name treasurer. But I left it at that.
Jim, what efforts were made to...
Both of those issues came up at the first convocation I chaired, but that's because I raised them. I raised them because some benchers and a number of people I knew outside of the Law Society had said to me both that they found the title treasurer confusing and obscure, and the Law Society of Upper Canada name similarly seemed antiquated, and that the overall impression given by these things was one of elitism and of refusal of change and all of the things that go with those sorts of attitudes. So I was content with the idea of changing both names, and indeed was in my own mind in favor, and I was prepared to support it. But I also thought that it would be unwise for me as treasurer to propose those things to Convocation, because they would be highly controversial, and it would be far better for Convocation to decide whether they wanted to look at those things themselves, and if they did, to decide what they thought about them. So all I said was that a committee might want to look at one or another or both of these ideas in due course. And in due course, a committee did, and one report was on the question of changing the name of the Law Society to that of the Law Society of Ontario. And I cannot now recall whether the report was in favor or against, but I remember the debate was lively and entertaining, and I thought it was decided when a former treasurer held in high regard by everyone rose with the yellow pages of the Toronto telephone book in his hand, and he said, "Upper Canada." And he read us all the entries.
Wasn't that Barrett?
It was Brendan O'Brien.
Was it Brendan?
He read us the entries, and he particularly emphasized Upper Canada Lager. And he said, we aren't the only organization with the name the Law Society of Upper Canada. Yeah. So the proposal was soundly defeated. As for changing the name of treasurer, the committee reported that they were in favor of changing it. That was put to a debate. And again, it was entertaining, it was stormy, it was at times hilarious. One bencher, again, very senior and highly regarded, strode back and forth in the Convocation room and said that he sensed and could hear the creeping feet of republicanism. And the final speaker in the debate, also a bencher of long service and long standing, rose to address Convocation, and instead of using the opening salutation, treasurer, he turned to me, turned to Convocation, turned back to me and said, "Comrade." That's when I knew that this proposal was about to be defeated, and it was. So no change was made either. And I must say, in retrospect, it doesn't seem to me that the Law Society has suffered by maintaining its traditions.
Well, this gets
Very
me
good.
into a more substantive question, and I'd like to get your views on this, because both of you have been an observer, a participant in the governance of the Law Society for many years, and as you know, other jurisdictions have lost. Other law societies have lost the right to govern themselves, govern the profession, and the common theory is because, for example, in England, the law societies were considered to be too clubby, too introverted, too focused on protecting their own, and the very use of the terms of a society, suggesting that that's not really what governing body should be doing. It should be regulating, and really what modern practice should be is to have an independent regulator regulating the profession and independent of the profession, and so on and so forth. But despite the fact that self-regulation has been lost in England and Wales and Australia, we here in Canada, and more particularly here in Ontario, continue to bump along with our ability to regulate ourselves in the public interest. So and I was talking about this issue with Frank Morocco, one of the other former treasurers, and he said, Tom, if you really think about if you really want to adopt that model, you can, but it will be saying something. It means we're going in a certain direction. And what is what do you think, or is there anything special or different about the way we do things or don't do things that has contributed to our ability to continue on as we have, and I wonder, if you could comment on how you see, sort of from a philosophical point of view, our approach should be to regulation. Is it a good thing that we still consider ourselves to be a society and not, many people not just as a regulator but doing other things? Could you comment on that a little bit?
Well, I think it's very important that we remain a society and we remain independent of government. I think that the legal profession, regardless of what the situation may be with other professions, the legal profession must be independent of government. We had this come up once when there was criticism of the way in which the courts were operating and the administration of the courts, and the government proposed a plan which would take the administration out of the hands of the court and put it across the street when the government was across, the government's offices were across the street, and run the show from there. I spoke against it, and Convocation passed a resolution to that effect, that this is a creeping infringement on the profession's ability to regulate itself and regulate itself without any interference by the government, because we have to recognize that the government is a litigant involved in cases before the courts, and presumably interested in many ways in what happens here in Convocation. So I think that anything that diminishes the profession's independence is, if we can prevent it, something to be prevented. I've seen other provinces where this has been a matter of concern. We were concerned about it from time to time. One of the advantages we had is that we maintained a very good relationship with the government. Mm-hmm. I don't know what the situation is now. I have no reason to think that we don't have a good relationship with the government, and I think it's highly important that we continue that relationship, because governments don't like to take on any more than they have to. They're happy to give it over to us. There was a situation here, you wouldn't have been in Convocation, it happened not too long after I came back, when we got into the paralegal issue. And I remember the Attorney General of that day, Michael Bryant, coming here to make the presentation. And I thought that Convocation at that stage had no alternative but to accept what the government wanted us to do in taking over the administration of the paralegal profession, if it is a profession, but whatever the paralegals were doing, because otherwise we could have found ourselves in a very difficult position, because it was important to the government, because of all the criticism, that somebody, and we were the logical party to do it, take this responsibility. So
it's almost the reverse of what was happening in other jurisdictions, giving us more responsibility.
That's right. And there was one time when the Quebec government were causing, they had a commission, forget the judge's name, Duchesne, I'm not sure if that's the name, but in any event, he did a report, and they couldn't buy a box of pencils without speaking to the government. So that we've been very fortunate. It's not just good fortune, it's good efforts on our part to maintain that kind of relationship, and we've maintained it here, to my knowledge and my observation, regardless of whatever stripe the government might be. And I think that it would be a great mistake to turn matters of discipline, for example, which is perhaps the most important function that the Law Society performs, over to an agency that isn't run by lawyers. I think that lawyers who are charged with various offenses ought to have their cases tried by their peers, so to speak, by members of the legal profession. Mm-hmm. Now we have lay persons in there to keep an eye on it too. Right. But I think that so many other, you could go on with this, but I leave it to you, Jim, to talk about it further. But I would oppose, as strong as I can at this stage, any effort on the part of the government to what I would call infringe in any way on the independence of the profession, and by talking adversely against society and some of the other things that we do, that's what it would end up doing.
Jim?
Well, it won't be a surprise that I concur entirely with Sidney's view and the reasons that he's given, and I'm particularly glad that he mentioned early on and emphasized the particular role of lawyers having to do with the courts and the administration of justice in the province, and the need for lawyers to be independent of all external considerations and forces and influences, including in particular government. And it's apparent to all of us, and Sidney, from his experience as a judge over his long term of service in the court, is clearly aware, as every judge becomes aware, that it's very important that when counsel are before you, the only responsibilities that they have are to their client and the court and to their professional obligations to the Law Society of Upper Canada. And they have to honor those obligations, but they don't have any duties to the government. No one can call them out. That's key to the system. I'm not saying that that couldn't be preserved if the Law Society or a similar institution for the governing of lawyers was largely or even perhaps entirely run by government, but I just think it would be a risky proposition, because it's very difficult for government to get into something and then not run it, because then they have the responsibility. It follows as a matter of logic and public policy that if they're in charge, they have to make sure it's working the way they think it should, and they have to be responsive to the pressures upon them. I think this gives government a very important and welcome buffer against those pressures. And indeed, I think it's common enough to have the experience in talking to people in government that they're glad that the Law Society is here. As it was put to me by one Attorney General, look, as long as you people are doing your job well, we're grateful and we don't want to have to get involved. So our hope for you is that you will keep on doing your job well. I think anybody who looks at the website of the Law Society and its reports will see that the range of activities that the Law Society has underway have clearly been designed to be responsive to contemporary public needs and concerns. And therefore, I think the Law Society is operating in a far better way than many other organizations which perhaps didn't keep up with the times and have received greater government involvement as a result. I attended and took part in a seminar at Queen's University a year and a half ago on this subject, and in the discussion, which included people with various perspectives on these issues, and not simply judges or lawyers, but legal academics and others, I never heard a proposition that seemed to make more sense than the existing system that we have now.
Okay, one final question, and this is somewhat selfish on my part, but I'd like you to tell me, what did you enjoy most about being the treasurer, and what did you enjoy least? Sid?
Well, it's a difficult question. I think that what I enjoyed most around here was the action. I enjoyed coming into this room. I enjoyed being in convocation room. I enjoyed my contacts with other benchers. I met some wonderful people that I wouldn't have met otherwise. There were a lot of issues at the time. We resolved them. We had an interesting time resolving them or trying to resolve them. We had a lot of fun. And so it was an action-packed 3 years for me, and I look at the whole experience as a single operation, and I wouldn't have missed it for the world.
Jim?
I can't report on something that displeased me. I suppose if I thought about it long enough, I could come up with something, but my recollection is, as Sydney's, the Law Society was a very special place to be. The people were good to work with. The staff, fellow benchers, I particularly relished, and I miss, the interchange, the exchange of ideas and debate informally, in the corridors, over lunch, in small group meetings, committee meetings, and informal convocation. It was all a wonderful experience. It was unlike anything else. It's unlike the kind of experience you have in practice, where you're always working on something where there are frequently two sides that are either opposed or at least with strongly different interests, and it's unlike the courtroom. I relished every moment of that.
You know, that's exactly my experience.
Yeah.
Exactly. I couldn't have said it better. The way the two of you have said it, it's nothing. That has not changed at all.
Yeah.
The predecessor, Pierre Genet, treasurer, I think about 4 years before me, Pierre's portrait hung in the convocation room to the left of the treasurer's chair. And I would look up at Pierre, and the portrait had been done with Pierre smiling happily. And I thought, Pierre is enjoying this debate. He always enjoyed the debates, and he's enjoying this one too.
Mm-hmm, mm-hmm. Well, you know, this is a really good note to, I think, end our conversation. And I want to thank both of you immensely for taking some time out to chat with me, because, you know, this is the kind of stuff I think people would love to hear and to see. So I'm really hoping that we'll be able to share it with a broader audience than just the audience of the former treasurers that we have that we meet as we meet on a sort of a semi-annual and annual basis. And so thank you very much for
Thank you,
doing
Tom.
this.
Thanks
Thank
very
you.
much.
Pleasure.
Okay.
Thanks, Jim.
Tom, it's an honor, and it's a particular honor to be here
And me
on
too.
the occasion of Sidney Robbins' 90th birthday.
Thank you very
May
much.
24th, a few
And his
days
long
ago.
service to the Law Society,
Yeah.
which continues.
Thank you, Jim.
Continues. Thank you very much.
Thank you.
Bye.
Thank you, Tom.